Hello everyone and welcome back to our channel. Today we are diving into the world of intellectual property laws, focusing on trademarks in India. Specifically, we will be exploring the Trademarks Act 1999 and its key provisions. So let's get started. To set the stage, let's talk about why trademarks matter in the globalized world of commerce. With the increase in the international trade, protecting brands, marks, and trade related aspects of intellectual property have become crucial. This need led to the adoption of Trademarks Act 1999, replacing the older 1958 Act. Now, what does the Trademarks Act 1999 cover? It introduces provisions like registration of service marks, extending the registration period to 10 years, filing of multi-class applications. It also recognizes the concept of well-known marks, aligning with the international systems and practices, and including the TRIPS agreement. So what exactly is a trademark and why is it essential? Trademarks are the significant corporate assets that distinguish products and services. While registration is not mandatory, but it is highly recommended. Why? Because it provides a legal protection to block others from using similar marks. It safeguards the reputation of the proprietor and their products. Now let's delve into the legal nitty-gritty. According to Section 2, Clause 1, Subclause M of the Act, a trademark can be a device, brand, heading, label, and more. It must be capable of graphical representation and possess distinct characteristics. Examples include logos, product packaging, or even combination of colors. The Act further defines trademark under Section 2, Clause 1, Subclause ZB. A mark must meet certain conditions, be visually representable, and distinguish one person's product or services from others. The key here is preventing confusion. In essence, a trademark must be visually distinctive and recognizable by consumers. In the ever evolving landscape, the non traditional trademarks like colors, shapes, sounds, and even smells are gaining acceptance. It is crucial to understand the distinction between the trademarks and brands. Trademark is not just about name or logo, it's a unique sign in the commercial organization representing the quality and goodwill. Now, let's talk about the economic value of trademarks. Successful trademarks generate brand loyalty, uniqueness, and market strength. Legal protection is the key to maintain this economic value. It prevents the new players from entering the market and diluting the brand's reputation. Before we jump into the Trademarks Act 1999, let's take a quick trip down legal history. Prior to 1940, India operated under common law for trademarks. The 1940 Act marked its turning point, introducing the registration and legislative protection. Fast forward to 1999, the Trademarks Act replaced its predecessor and bringing significant changes in the legal landscape. Now, what exactly does the Trademarks Act 1999 entail? This act is a comprehensive piece of legislation designed to protect the public from fraudulent use of trademarks. It also strikes a balance between granting statutory rights to trademark owners and safeguarding the interest of other traders. But why do we even need trademarks? Trademarks are like superheroes of branding. They safeguard your brand, differentiate your products or services, and build trust with customers. Whether it is the shape, color, or product packaging, trademarks can help customers easily identify and connect with your brand. Now let's talk about the importance of registering a trademark. A registered trademark becomes a statutory asset for your business, gaining value over time. It establishes ownership, prevents unlawful use, and fosters a trusting relationship with your customers. The objectives of Trademarks Act are multifaceted, derived from constitutional provisions, statutory laws, and international obligations. It aims to prevent the freedom of trade, safeguards businesses, and promote the public interest. Now, what are the features of Trademarks Act 1999? It defines service marks, introduces the collective marks registration, it prohibits marks imitating the well-known ones. It also streamlines processes, allowing a single application for multiple classes, extending the registration period term, and allowing a grace period for renewals. First things first, who can register a trademark and how? Well, the Trademarks Act allows anyone claiming ownership or intending to use a trademark to submit an application. This includes individuals, businesses, partnerships, and even government entities. The application must contain specific details like the goods or services, class, applicant's info, and the usage duration. Now, not every trademark gets the green light. Section 9 of the Act outlines the absolute grounds for denials. If a trademark lacks distinctive characteristics, contains offensive material, or goes against certain legal provisions, the registration can be refused. It's a way to ensure that trademarks have a unique and acceptable identity. Trademark law involves a fascinating similarity test. When considering deceptive similarity, it's not just about looking at marks side by side. We evaluate the essential features, including structure, visuals, and sounds. Now let's talk about the relative grounds for refusal under Section 11. If there is a likelihood of confusion with an earlier brand or trademark, the application might be denied. This is to protect the reputation of the existing trademarks in the market. Now, what happens if someone opposes our trademark registration? Section 21 and rules from 42 to 50 come into play. There is a notice of opposition, submission of counter statements, and a provision for evidence. It's a legal process to ensure fair consideration of objections. Moving on to Section 25, this section details the procedure and registration period. The trademark can be registered for 10 years with the opportunity for renewal. Under specific conditions, the trademark registration can be restored or renewed. Did you know that unregistered trademarks have a different legal standing? Section 27 states that no infringement action lies against unregistered trademarks. However, common law rights against passing of goods are recognized. The concept of passing off, while not defined in the Act, is recognized by common law rights. If someone misrepresents goods or services intending to benefit from another's reputation, legal action can be taken. Infringement is a significant concern. Section 29 outlines the scenarios where unauthorized use of similar or identical marks can lead to legal consequences. It's all about protecting the distinctiveness of a brand. Section 103 deals with penalties of false trademarks. Filing of false trademarks can result in serious consequences, including imprisonment and fines. It's a reminder to uphold the integrity of the trademark system. Section 91 of the Trademarks Act, which deals with appeals to the appellate board. However, recent reforms in 2021 have significantly altered the landscape. Few of the changes introduced are abolishment of the Intellectual Property Appellate Board, Procedure for mark cancellation under Section 47 is now heard by Registrar or High Court. Mark correction under Section 57 is now shifted to the relevant High Court. Appeals under Section 91 now redirected to the High Court. We also need to understand how a claim for trademark infringement can be delayed under Section 124. This occurs when defendant challenges the mark's validity, leading to a pause in the proceedings. Moving on to Section 134, it outlines where a lawsuit for trademark infringement can be filed. It could be a district court or high court based on plaintiff's residence, business or gainful employment. Typical reliefs includes permanent and temporary injunctions, compensation or an account of profit, transmission of infringing labels and destruction or erasure of markings. Additionally, interim reliefs may involve appointing a local commissioner for searches and seizures, ensuring a fair legal process. Now let's delve into the concept of acquired distinctiveness. Each trademark designates products from a specific source, and over time it becomes stronger. Section 9, Clause 1 and Section 32 of the Act address acquired distinctiveness, stating that even if a mark has acquired secondary meaning, it can still be registered under certain conditions. Legal precedents such as Godfrey Phillips India Limited versus Kirnar Food and Beverages and Isi Khoshla versus Anil Agarwal highlight instances where descriptive marks are protected if they acquire any secondary meaning. In our mind, a question arises: how to establish the distinctiveness of a mark? So there are factors in determining the uniqueness. They can be market share, extensive geographical and long-term usage, marketing expenses, public perception, statements from business organizations. Challenges arise in attempting to establish the distinctiveness, especially for common descriptive words. Factors such as market share and public perception play a crucial role. In the year 1999, the Delhi High Court made a groundbreaking decision. This marked the first time in India that a court acknowledged the significance of domain names, granting them the same protection as traditional trademarks. Yahoo India's domain was at the center of the dispute, and the court highlighted the potential for user confusion, emphasizing the gained distinctiveness of the term Yahoo. Even a disclaimer, the court ruled, could not rectify the issue. This sets a precedent for the intersection of trademarks and the digital realm. Fast forward to 2004, the Supreme Court of India, in the case of Milmet Ophtho Industries versus Allergen, addressed the protection of international brand Ocuvlox. Here the court emphasized the importance of preventing confusion in the healthcare sector, even if the trademark had not been registered or used in India. This decision underscored the significance of being the first to enter the global market and shaping the narrative around trademark rights. Jumping ahead to 2021, Sony Corporation versus K. Selvamurthy brought trademark infringement into focus. Sony Corporation sued Sony Tours and Travels, alleging the dilution of its iconic trademark Sony. In this instance, the court carefully considered the distinction between the Sony's electronics and media business and the defendant's tours and travels operations. The court recognized the absence of consumer confusion and acknowledged the plaintiff's delay in legal action, shedding the light on the importance of timely litigation. Continuing our legal journey, we encounter the case of 2021 of ITC Limited versus Moria Hotel Madras Private Limited. In this case, the Madras High Court allowed the addition of trademark infringement remedy to a passing off complaint, showcasing the flexibility of a legal proceeding. The court stressed the utility of adding remedies to avoid multiple litigations. It provides insights into the strategic aspects of the trademark litigation. Last but not least, we explore the case of 2021. Last but not least, we explore the 2021 case of Sun Pharmaceuticals Industries Limited versus Cipla Limited. This case delved into the copyright and trademark violations in the context of an ongoing medical emergency. The court, while acknowledging the urgency of the situation, issued interim injunction, emphasizing the importance of protecting the intellectual property rights even in the face of unprecedented challenges. In conclusion, the Trademarks Act 1999 is a crucial piece of legislation in India, aligning with global standards. Understanding its provisions is vital for businesses to protect their intellectual property and thrive in the competitive market. A comprehensive overview of some pivotal trademark cases in India have not only shaped the legal precedents but also have influenced the broader conversations around intellectual property rights. If you found this video informative, please make sure to like, share and subscribe to our channel for more educational content. Until then, keep exploring, keep learning. I will see you in the next video. Goodbye.